All right.
Well, welcome all of those who are now piling in. I think we've got about just before 12 Eastern time, so we'll give everybody another minute or two. I got a fair number of people joining today, which is great news for my colleague here, Russ Willis, to talk us through the prearranged sale issues and some of the recent developments there. So, like I said, get ready a minute or two. For those of you who have already joined, if you can always help us out as we've done previously, if you can perhaps raise your hand or put something in the chat saying that you can hear me and see the screen. So two important things for any webinar, as we all have learned. So good, good, good. Tons of hands going up. Thank you very much for that. So as I said, we'll wait another minute or two and go ahead and get started. Well, it looks like it's 12:02, so I want to be real respectful of your time and make sure that Russ has plenty of time to be able to go through his presentation, and I'll be interjecting, excuse me, as we sort of go through here a bit. So a couple housekeeping notes so you can, I know, see the screen, so always most important. Similar to past webinars, we've been doing this monthly. I think a number of you have attended past ones, which is great. They are all free, and then what we will do is record this session, include the full recording. We're doing it on Thursday as well, as you know, so there always, strangely, is a better recording of the two. So we will record the best one, post that on the webinar section of the Charitable Solutions website. And what I would encourage you to do is, as you have questions, which I'm sure you will, if you can include that in the Q&A portion of the Zoom website, ideally rather than chat. It's a little bit easier for us to scrape those. I'll do my best to sort of answer those in real time as we're sort of going through the presentation today. If there are certain things that are more helpful for Russ, then I will sort of interject and take the MC's prerogative to sort of ask him those questions sort of as we go. And then there'll, I'm sure, be some other questions that may not be as conducive or we just frankly just don't have the time for. But what we've done in previous webinars as well is we then include all the Q&A, include obviously the A part of the Q&A, and then post that as part of the webinar. So you'll get the benefit both of the questions today and the questions on Thursday. One other question that comes up all the time, and so I'm anticipating it now, is will we share the slides? We have not done that traditionally. We used to do that. There have been some that have been, we'll say, nicely misappropriated, which annoyed me, frankly. No good deed, right? So these are already free. It's like, give me a break. But anyway, and I've learned that people who like to misappropriate things, at least in my experience, tend to be rather lazy. So even though they could watch the free video and recreate everything, they don't tend to do that, which is odd to me on a couple levels, but I digress. So there will not be any slides that will be sent out. Again, the entire presentation, you can start and stop and do all kinds of fun stuff, is available on the website, or will be available on the website next week. By the way, in addition to another 10 or 14 that we already have, I guess 12 or 14 for past webinars that we've done too. So with that, we will jump right in now that all the housekeeping is out of the way. So avoiding the gray line, closer recent scrutiny of non-cash charitable prearranged sales. So Russ will be guiding us through today. I'll introduce him a little bit more after we go through the first slide. I'm Brian Klontz, by the way, and so work with Russ as part of Charitable Solutions as well. So excellent timing, Russ. Very good. I didn't even have to give you the cue. So this is what we do. This will be a sort of a 5-minute quick overview, hence the free part of these webinars to jam a little propaganda on the front end. So we do odd things even for people in this field. So we are a charitable gift risk management firm, and the bottom line is our mission is to help make gifts happen that otherwise wouldn't, period. And we do that through both structural and process and hopefully expertise around risk management for the only two types of gifts that charity can actually lose more money than the original donation. So number one are non-cash gifts, and number two are gift annuities. So sort of right side, do a lot of work in the charitable gift annuity risk management area. You can see the stuff there. We have two actuaries on staff. So we do a lot of stress testing of larger gift annuity pools, modeling, et cetera. And then we also spend a lot of time on very large concentrated risks. So we just worked with a charity 60 days ago, I guess, that had a $15 million gift annuity. I worked one with $27 million gift annuity. So it's usually $1 million or more. People tend to call us to figure out how might be best to manage that contractual risk. And to some extent, that goes to sort of reinsurance versus self-insurance where that makes sense and so forth. So that's the gift annuity risk management. We do some around charitable estate settlement as well, so primarily around more complex type situations, usually involving either international assets or non-cash assets or something just kind of funky going on. So we have another partner that specializes in that. And then sort of going middle, center down, virtual currency, certainly in the news to the nth degree of late. So we've done a very large number of crypto donations through our platform, which I'll mention in a second on our Decamai Foundation side, but also do life insurance and crypto qualified appraisals. And so provide additional tax compliance there. I'm doing about 10 to 15 virtual currency appraisals a week right now, so lots and lots of activity in that space to be sure. We do a lot of these type presentations for CE, staff, board, particularly in the community foundation space, but just another thing obviously that we do. And then on the left side is really where the core of our activity is. So non-cash asset risk management. We do some direct consulting in that space for charities who wish to take in the asset themselves, and that's probably maybe 5% or we do just do that on an hourly fee basis, of which Russ helps us a fair amount as well on that. And then probably the other 95% of the activity would be what we've called the outsourced model. So we have the Decamai Foundation, Decamai Asset Trust, two national donor-advised funds that do nothing but take in illiquid or complex gifts that other charities otherwise have declined. You can see there we do a lot of that. So about $1.6 billion now have been donated through that platform, about $1.1 billion of that in the last 3 years. And last year alone, it was 90. We found another gift, 99 donations last year, almost 100, 99 donations for $363 million in total value, 100% of which were initially declined, 100%. So it's where we always say a good donor wanting to do good things with a good asset. For whatever reason, the charity might not be able to take it in because of the complexity. Perhaps UBIT, we do a lot in the S-Corp and UBIT space as an example. As I said, either a real quick turnaround, expertise issues, risk concerns, whatever, and gift acceptance policies, and they may otherwise say, yeah, this is not going to be a good fit for us. How about you call the team over at Charitable Solutions? We've got a 16-person team just dealing with these types of donations and transactions. And the average fee on that, by the way, has been about 1.4% at the time of settlement. That's a donation to our charity. And then we, again, the other unique thing is 30 days after the sale, we then make a grant to the charity or charities that the donor was trying to give to in the first place. So we're a donor-advised fund in all respects, only in this niche area that we focused on for 18 years, and then to be able to help, again, donors make gifts otherwise that would not be possible. And the final piece, which is exactly the same as the non-cash asset risk management side, is we have another charity that we operate called the National Gift Annuity Foundation. So we operate in 49 states, everywhere but Hawaii. You can see there are 575 contracts, growing about 20% a year right now, 44 million in assets. We are by far the largest independent CGA pool in the country, and I think we're number 2 or 3 of total CGA pools in the country. And so bottom line is, if a donor is trying to make a gift annuity donation, let's make up to a university who's not registered in New York or California or Washington, as an example, or a smaller charity that just doesn't want to operate their own gift annuity pool, rather than declining that gift, they would refer the case over to the National Gift Annuity Foundation. We issue the contract. There's no agreement between us and the charity directly, so we're not acting as your agent. You're not paying us anything. And then 100% of the residuum, the remainder at the end of that, can then, just like the non-cash side, be granted to the charity or charities that the donor, again, was trying to give it to. And we charge 2% per year on the market value, 1% for all compliance, loss reserve administration, and investments, and then 1% for operating for our staff. We've got a team of 4 specializing just in that area. So long story short, that's it. Charitable Solutions. Just wanted to give you some background there. And again, we make gifts happen that otherwise wouldn't. So very much in that regard, and the purpose of the webinar today, we deal a lot with the non-cash side, as I mentioned, and probably a third-ish of the referrals that we get, there is either clearly a prearranged sale issue or we're bumping up against it quickly. And so this question comes up all the time. We've had the great pleasure of working with Russ. Has it been 3 years, Russ? 3, 4?
At least. I'm off and on longer ago than that, but yeah, it's on a steady basis, at least 3 or 4 years, yeah. Mm-hmm.
Yeah, and I think it was probably 15 years at least off and on, and known Russ back in his St. Louis estate planning and legal days 20, 25 years ago. So great addition to our staff. He heads all of our tax and legal research, and as deep as areas you can get, primarily around non-cash, but also around gift annuities too, in terms of his work. So with that, Russ, eager to hear your comments. I'll interject from time to time, and I'll be watching the Q&A as we go.
Okay, thanks so much, Brian. Good morning, everyone, or good afternoon, I guess, where you all are. It is not snowing here in Tucson, Arizona. And I won't take another 5 minutes to talk with you about my consulting practice and my newsletter and my asynchronous webinar series on plan giving. You can find all that on my website when you choose to, but I would encourage people to interject with questions. I won't see them the way the screen is set up here, but Brian will retrieve them. We can answer some as we go along. I actually encourage that kind of thing because it means that we all know that we're talking about the same thing. Sometimes it's difficult to encourage people to ask questions, but I welcome them. And as Brian mentioned, we will address all of the accumulated questions in writing within a couple of days after we finish this process. So here's today's agenda. We're going to be talking about prearranged gifts, obviously, but I want to begin by talking about where this whole discussion is situated in terms of tax policy, and the fact that there are these strong incentives in the tax code to encourage people to make gifts of appreciated property. We'll go into some detail on that. We'll talk about the fact that as a practical necessity, the recipient charity needs to be in a position to unload these assets as they come in, because otherwise we don't have diversification and so forth. So we're going to talk about that. Then we're going to go into a little bit of history of the case law on prearrangement, and highlighting in particular the case that everybody's familiar with, the Palmer case, and what we all thought was the safe harbor at Revenue Ruling 78-197. And talk about, actually, there are some differences between Palmer and the revenue ruling, and that's kind of where these problems arise. A little bit of the case law on this, and where the tax code has been heading, where some of the federal appeals courts have been heading, and what IRS has been trying to do, which doesn't necessarily mesh with those other directions. And then finally, after all that preliminary, we'll finally talk about the Dickinson case itself, which was decided last November, I think, or October. And in particular, how that case indicates something about where IRS is turning their attention on what I'm calling the second prong of the revenue ruling. And then after all of that, then we'll take a little bit of time to talk about a case that hasn't been decided yet, that is pending in federal district court in California, where donors named Fairbairn have been suing Fidelity Charitable for Fidelity's handling of the stock that they contributed. So we'll get to that toward the end of the hour. So let's launch. Tax policy. As I indicated, there's a very strong incentive in the tax code for the contribution of appreciated property to public charities. this incentive, when you're contributing to a private foundation, the incentive really isn't there, except in the case of publicly traded stock, and even there, only in the case where the amount that you're contributing does not comprise 10% of the outstanding stock, in combination with other gifts of that same stock you have also made to private foundations. So I mention all that because in a weird way, it actually comes up in connection with Fairbairn. So what does this incentive look like? Well, they give you a full deduction at fair market value, okay, for the appreciated property that you've contributed, but that deduction offsets your ordinary income. And so you're foregoing the recognition of long-term gain, but you're getting credit for that asset value for your deduction. And what it's offsetting is ordinary income. That's a very strong tax incentive. So I just want to mention that if what you're funding is a life income gift, you will recognize some or all of that gain over time. If it's a charitable remainder trust, your unit trust payout or your annuity payout is going to carry some of this realized gain out until you've exhausted it, and it may take 20 or more years. And similarly with a gift annuity, as you recover your quote unquote investment in the contract pro rata over the expected return multiple, a component of that recovery will be the realized gain on the purchase of the contract. It's kind of like having access to an installment sale, which you normally would not get with marketable securities or, of course, with any other property. It's kind of like an installment sale in that respect. But if it's an outright gift to a donor advised fund or outright to a public charity, you just plain get the full benefit of the fair market value for the deduction. No income recognition, no recognition of the gain. Yes, it's subject to a lower percentage limitation, but that's really just a timing issue. So it's a very strong tax incentive, okay? Unless, okay, you get caught in this problem that we're discussing today, which has to do with what is the nature of the prearrangement. As I mentioned before, the recipient organization does want to sell this property immediately, even if it's marketable securities, because it's going to throw their portfolio out of balance. Okay, so they need to sell. And if it's a non-voting interest in a closely held business enterprise, which Brian can tell you is a large part of what we're doing over at Charitable Solutions, any pass-throughs from that entity are going to be taxed to the exempt organization as unrelated business taxable income. So there are two reasons why the recipient at least two reasons why the recipient organization wants out. Okay, they're happy to facilitate the contribution and the tax benefit of the contribution, but of course they want cash for their needs, and they don't want this exposure to the risk of the investment and to unrelated business taxable income. If the asset in question does not have a ready market, then the recipient organization is going to want to have an exit plan in place as part of the gift acceptance process. So in particular, when we're talking about interests in a closely held business, normally the shape of that exit plan is going to be a redemption back to the issuing corporation or to the partnership. In the case of real estate, it's going to be that there already is a ready buyer out there who has been identified, or the market is so strong that we have a high level of confidence that we will find a buyer quickly. But the organization needs an exit plan. Okay, so if that exit plan is structured in such a way that it's already a done deal at the time that the gift is made, IRS, to the extent that they have the capacity to examine these things, will be looking to see whether, as a practical matter, form over substance, substance over form, what has really happened is you had a sale, but right before you closed the sale, you moved the asset over to the charity so that it was the charity making a sale, but the deal was already done. If IRS thinks they can make that case, they will take the position that that's how the transaction should be reported, that it's as though you had sold the asset and contributed the proceeds so that you do recognize the gain. That's what they're looking for. And that's the shape of the transaction. So this is what the concern about prearrangement is. We want prearrangement. The recipient org wants the prearrangement because it helps facilitate this process of making illiquid gifts and then turning it into cash and benefiting the charity. But IRS also wants us as exempt organizations not to be selling our exempt status in order to facilitate tax advantaged transactions for people if all it really was at their end was a sale. Okay, so how do we know when we have a prearrangement that's going to be vulnerable? The case that everybody turns to in this is a tax court decision from 1974 called Palmer. And Palmer actually had reasonably what you might call egregious facts. The taxpayer was on both sides of the transaction. It was his closely held corporation. He contributed a controlling interest in the corporation to a private foundation. This was pre-69 when you could still do things like that at full value. A private foundation which he also controlled. So day after this transfer of stock, then sitting in the other seat as foundation director and holding a controlling interest in the corporation, he then voted to redeem the stock. IRS quite naturally felt that this was something where they should sort of switch the cards and say, no, this was really a sale and you contributed the proceeds. The tax court actually, this is a taxpayer victory. The tax court said, at the moment that the stock was contributed, the foundation was not under an obligation to redeem. And then once it was in the hands of the foundation, in his capacity as foundation director, the taxpayer then had a fiduciary responsibility to act in the best interest of the foundation. The tax court respected both of those features of this transaction. Fantastically enough, it was the taxpayer who appealed. The IRS did file a cross appeal, but they dismissed it. The ground on which the taxpayer appealed was they weren't satisfied with the value that the tax court allowed them on the value of the stock. But that's the Palmer decision. And it's a taxpayer-friendly decision. IRS wasn't thrilled with it. They actually did initially appeal, but they walked away from that appeal. But what the court was saying was that if we can see that the gift was actually complete before anybody took a vote for redemption, and then the recipient organization acted in its own interest, then we will respect the form of that transaction. So the question then becomes, is this an enforceable contract when, and who is it who can enforce this contract to purchase the stock? It took IRS a few years to finally acquiesce in Palmer. They acquiesced only in the result. And what's interesting about Revenue Ruling 78, well, there's, I guess, 100 things that are interesting about it, but the things that are interesting in today's discussion is that they acquiesced in the result in Palmer, but they framed the issue differently from how the tax court had framed it. They said they weren't going to challenge similar transactions unless the organization received the property subject to an existing obligation to sell. So they're focused on what is the obligation of the recipient organization, whereas the tax court was actually focused on, did the taxpayer, the shareholder, at the moment of the transfer, have an enforceable right to the proceeds? And the reason the tax court said no in Palmer is because there had not been a vote yet to redeem. So IRS is kind of flipping the equation here, saying we will challenge it if the organization is receiving the property subject to an existing obligation to sell, or, and this is what we're going to be calling prong 2, or the second prong of the revenue ruling, or we will challenge it if the issuing corporation can compel the recipient organization to surrender. This is exactly what we're going to be talking about when we get to Dickinson. So that's the revenue ruling. It's seems to be in the specific context of a stock redemption, but everybody understands that it also applies to real estate and the whole everything else. So it's widely understood that somewhere between Palmer and Revenue Ruling 78-197 are the rules that we're looking for. So the tax court has said more than once, that's not our rule, that's your rule. Revenue Ruling 78-197 is a statement by IRS of what will be their litigating position in similar cases. But we, the tax court, have our own rule, and our rule is Palmer. Okay. So, and this actually comes back to haunt IRS. They're in a case called Rauenhorst back in 2002. The tax court said, listen, IRS, what you're trying to argue here is that the revenue ruling shouldn't apply in this situation. Okay, that the argument IRS was making was that as of the time of the transfer of stock in Rauenhorst, that everybody understood that the deal was going to go through. There was nothing that was going to derail this deal. It was a done deal. It was practically certain to happen. But they had not taken the vote yet. They had not taken the vote yet, and the tax court said, it's your revenue ruling. Okay, you've told people that you're not going to challenge it unless there's an enforceable obligation in place. So don't come into our court and argue differently. That's your revenue ruling. You're stuck with it. What IRS was trying to accomplish was something that was similar to what had happened in Blake. Notice that Blake was a taxpayer unfriendly decision at the tax court level, which was affirmed on appeal to the Second Circuit. But what happened when it got to the Second Circuit was that the appeals court took a slightly different view as to why they were affirming. Okay. It's almost too complicated to even describe the transaction in Blake, but the guy had contributed stock in a closely held corporation. The understanding was that it wasn't a foundation he controlled, it was a public charity, but the understanding was that they would turn this stock in for redemption, but then step two, they were going to use the proceeds to buy a yacht from the taxpayer. So there was all this a prearrangement on the line that the taxpayer would not have made the gift unless he understood that the charity would follow through. So what the appeals court said was the recipient organization, there actually was a contract here that they were obligated to perform. That sounds more like the revenue ruling. Okay. But the appeals court noted that the revenue ruling, maybe gave too much ground. The revenue ruling, has a more limited case than the tax court was actually articulating in Palmer. So on the strength of Blake, IRS came into Rauenhorst and said, look, it should be more like this instead of like that. And the tax court said, we're not going to listen to this because you have this revenue ruling out there and you are bound by that. So all of that is by way of background to Dickinson. I don't know that I have anywhere in this slide deck mentioned a case called CREM, C-H-R-E-M. It's actually still pending. Well, actually, that's not true. There is a final decision in that case. But what had happened there was that the shareholders, the stockholders, were on both sides of the transaction again. It was a merger up into another corporation that was going to be fully invested in an employee stock ownership plan. And the ruling in CREM was actually just the tax court. It was a tax court memo decision. Both sides had moved for at least partial summary judgment. And the tax court said, there's disputed facts here. We can't actually give you a ruling on partial summary judgment on either side. This has to go to trial. And in the end, the case settled. But by saying that, the tax court kind of indicated that it might be open to listening to IRS arguments on the question of prearrangement, short of a vote that has already been taken on a stock redemption. So what happened in Dickinson? Okay, Dickinson was a case where we had an enterprise down in Florida. I forget exactly what they do, some kind of construction work. And all of the stock in this corporation was held closely by its executives in the corporation under a restricted stock agreement. And actually, that restricted stock agreement had a feature in it that said at any time, the board of directors can call your stock. Okay, you can't transfer it to anybody outside your family, and any transfers that are going to, take this down through generations, the board needs to approve. Okay, so that was the nature of the restricted stock agreement. So you would think you can't really make a gift of that stock to a donor advised fund at Fidelity. Nonetheless, this is what was going on, and it was going on with the approval of the board, because the board understood, and you can find the board resolution actually in the record online. It's kind of hard to find records online at the tax court these days, but I have copies if people need to see this. But the corporate resolution literally said, we understand that Fidelity has a policy of immediately selling closely held stock. So we have confidence that they will. Okay. If we need to, we'll call it. Well, they never did need to call it because Fidelity was in a hurry to get rid of it. So that was the only reason this stock even made it over to the donor advised fund at Fidelity. IRS said, well, wait a second, we do have this revenue ruling. I know the tax court has never accepted our revenue ruling, but prong 2 of our revenue ruling says if the corporation could compel the recipient organization to tender the stock for redemption, we will call that a prearrangement and we will try to rearrange it for you. Um, so, uh, so this was, the taxpayer here was named Dickinson, but there were several others in this corporation that were also doing this. The board of directors specifically waived the restrictions in the stock agreement because they understood that Fidelity was going to tender. So let's think for a moment about, we talked very briefly about Blake, this whole idea of promissory estoppel. I would never have given you the stock unless I already knew, and we had a sort of an agreement that you would sell it back and use the proceeds to buy my yacht. Okay, promissory estoppel. It seems like Fidelity, in a way, kind of did make a promise here. They were promising that they would tender this stock for redemption. But who were they making that promise to? Did they promise that to Mr. Dickinson? Not really. They were promising, well, that is who they were making the promise to, but who was relying on that promise? It was the corporation, not Mr. Dickinson per se, who was relying on that promise. Would he have made the gift? Well, he would have liked to. He would have liked to make this gift, even if he thought that promise wasn't enforceable. He didn't really care what Fidelity did with that stock after it was gone. Probably in a way he did, because he also sat on the board and he was among a small group of closely held shareholders. So he, in a way, he probably did care. What action exactly did the promisee, and who is the promisee, take in reliance on Fidelity's promise to immediately tender this stock for redemption? And if that was the setup, if we could reconstrue this as a sort of a promissory estoppel analysis, which, keep in mind, the tax court has not accepted promissory estoppel as its analysis. But if we were trying to reconstruct it that way, would it turn out that our gift to the donor advised fund was conditional? I would not have made this gift unless I understood that you were going to tender it back. Okay, so that's prong 2. It's not something that the tax court is willing to enforce. They have their own rule, and their own rule sort of still looks like Palmer after all these years. Did Fidelity, this is the revenue ruling analysis, did Fidelity receive the stock under an existing obligation to tender? Well, no, because it hadn't been called yet. And in fact, it never was called. Fidelity just tendered on its own within, a week, 10 days, 30 days on each of these various transactions. Could the issuing corporation have forced the tender? Yes, they could. So, if IRS had its way under the revenue ruling, then this would have been reconstrued. But the tax court doesn't go that way. So IRS is still trying to fight this fight. And if CREM had gone to a decision on the merits, we might have actually seen a shift in how the tax court is ruling on this, because the rulings on cross motions for partial summary judgment actually did seem to indicate that the tax court was receptive to these arguments. So this is kind of where we are today on on Dickinson and prearrangement. So that would be our
And Russ,
transition point for fidelity. So yeah, I want to stop for Brian. Come on in, Brian.
I'm definitely in. So very, very good overview. And I think as these things sort of layer on top of each other, parsing out the distinctions relative to facts and circumstances, you sort of didn't go, which is okay, sort of into the Ferguson sort of case, but sort of the whole notion on sort of how tenders work and that 50.1%, more of a bright line test versus some of these others that are a bit more murky on facts and circumstances. But I really want to open this up. I've got a couple questions just myself that we get often since we're in this work so much before we go on to the Fairbairn case. So just to let everybody on the webinar here know, we'll be leaving generally the prearranged sale sort of general context, although we're sort of in a first cousin element of that in Fairbairn. So any questions you have, sort of now is the time on prearrangement. Two that I have, which many of you may be thinking about, perhaps, is we do, Russ, a lot of these transactions that typically still are in letter of intent stage. And then there is the whole notion, we'll pick on real estate, of, well, even if there is a purchase and sale contract, under the sort of is it more likely than not to go through, there are some that might have, 57 zoning contingencies. That's obviously hyperbolic, but you get the point, where they're saying, look, we are so far from this likely going through that we still feel comfortable. So I don't want to have you put on your hat from a while ago when you were sort of practicing as an attorney representing clients, but sort of how would you counsel them, understanding there's sort of continuum of perspectives from both the legal or advisor side, to be sure, but also sort of obviously the risk tolerance of the client as well. But sort of how do you sort of talk through that issue? And then I've got another one after that.
Well, ultimately, of course, the question that needs to be asked is, if this deal fell through tomorrow, are you in a position where you could have sued the prospective purchaser for failure to perform? Okay. What's scary about Ferguson, I'm glad you mentioned Ferguson, is because they did have, the 50% participation, 51% participation and stuff, but there were a lot of unmet contingencies that the purchaser could still have exercised to say, no, we're going to walk away from this deal. And some of them were pretty bad contingencies, like the factory burned down, but they were still determined to go through. That was not a taxpayer victory, and because the tax court took the view that everybody knew that the purchaser was going to waive those contingencies because they were so eager to buy the goodwill that was being generated by this one shareholder who was, going to stay on in a managerial capacity. So, that's kind of a soft question. How certain are we that this deal is actually going to close? And if it didn't close, is there something enforceable in the wreckage where you could say, you promised that you were going to buy this, and I now have a cause of action against you because you didn't. That's what makes Ferguson so scary. But again, it's a case in which the appeals court affirmed on a different ground than the tax court had articulated. So this business about, practically certain to close, that's not the tax court's language, and they have not embraced it. But that's the Ninth Circuit, and I forget where the Blake was, Fifth Circuit, I think. So there are some circuit court opinions out there that are taking a more, IRS-friendly view on these issues than the tax court presently is. But as I'm suggesting, the Krem decision, although it never really went to a final reviewed decision, kind of indicates that there might be some receptivity at the tax court for this kind of argument. But, reverting to your question, what do you advise? I would advise not having an enforceable sale contract in place at the time that you make the gift. And then the question, you need to close the contribution to the charity at a moment where the buyer could still legally walk away. And I know that feels uncomfortable. But the tax court has not embraced this practically certain to close idea. They are looking at enforceability, and they're looking at enforceability from the side of, at the time you gave the property to the charity, were you already entitled to receive proceeds? Okay. If that's not the case, the tax court still has your back. IRS is still trying to fight this question of, well, yeah, but was the charity receiving this under an obligation where if the buyer shows up, they have to sell? That's the IRS's view on this. And that, there's a bit of a disconnect there. That's IRS's hobby horse, and they are going to pursue it when they can. That's the lesson from Dickinson, is they're going to pursue it when they can. And they're just still struggling to find a receptive audience over at the tax court. But the concern is that they may eventually be finding a receptive audience there. Somewhere in there, I hope I answered your question. So,
you definitely did. And
okay.
I would just say from a practical sense on the charity side, there's sort of two things I want to maybe tease out. And best practice is I think, quite strong. But certainly as it relates to privately held stock, one thing we say is, the whole point of a letter of intent is it says it's non-binding, like literally on every other page, like there's actually the words on every other page by design. And number two is, to the extent that we actually receive the stock, being able to make sure that we are part of the cap table and listed as an owner on the purchase and sale contract certainly would seem to create some pretty good optics, saying, well, the charity had to own it before there was this enforceable contract, all things being equal, certainly
Sure.
component of the contract itself. So the point is, every donor wants to wait until, we always call it the Cinderella moment, right before the second hand hits midnight. Don't give it 2 seconds before, but at the same time, we're sort of bumping right up against the whole prearranged sale assignment of income sort of concept or construct. And so that sort of LOI stage tends to be something that we sort of see a lot of. One thing that I would say, and I'd be very curious, we haven't spoken about this directly, but very curious about your thoughts here, and that is, everything we're talking about, everything that you have shared is within the lightning rod is the donor all through this. And so there are certain charities, very understandably, that would say, do we really want to get pulled into the muck where we think that this is a prearranged sale? And where I'm going with this is, I find this sort of interesting, not just theoretically, but this happens 2 or 3 times a year with us, where we'll have a conversation with a donor, in many cases real estate, and the real estate donor will say something along the lines of, paraphrasing, look, I was going to sell this building and give the net proceeds anyway. That's what I was going to do. And my advisor said, well, wait a minute, there may be a way that we can help with that, based on things, Russ, that you mentioned earlier in terms of the tax optimization of doing it before versus after, as we all know. And then let's also say that the facts are that there's a purchase and sale agreement, lots of signatures, lots of dates. I mean, it's maybe tax court and others would go, that's pretty far. You're like landing on the sun on this one. You see where I'm going?
Oh, yeah.
There are a certain number of donors, in concert obviously with their advisors, that say, well, what happens? What's worst case? Worst case is assignment of income, capital gain, phantom, back on me. I was going to do that anyway. I was going to sell it anyway and have all the capital gains tax. Now, the enjoying conversation with the IRS would not be fun. Interest, penalty, none of that's fun. I don't want to gloss over that.
Yeah.
But there are a certain number of donors that kind of say, well, what's the probability that I can be audited anyway?
Oh, boy.
You get into that scenario. It's basically it's almost an audit roulette of, I'm just throwing these numbers out, so we're not giving tax legal advice, so all these good disclaimers. But it's a 2 to 4% chance I'm getting audited anyway.
If that.
So, if that, exactly. I was erring to the side of being a little bit more liberal, but let's do it. Let's just full prearranged sale. I'm making the donation. Done. We'll just see what happens after. So I guess on the charity side, you can get the fun IDRs from the IRS on the conversations, but I guess just in general context, if you had a client super risk tolerant, I'm not suggesting you recommend it, to be clear, but I just want to be sort of parse out how bad is it, and what's sort of I'm a risk manager, what's the probability of occurrence and how severe is it if it actually happens, and sort of maybe to tease that piece out a little bit.
Yeah. That's interesting. I guess I feel that I need to always throw in the footnote here. Anybody who's on this call who is subject to Circular 230, in other words, practicing before IRS or the tax court, needs to keep in mind that written advice can never reference audit risk. So don't do that. But yeah, it's I think it's probably fairly common for people to have almost all of the chips in place before an advisor wakes up and says, why don't we do it this way instead? And the tax court has been openly friendly to that, at least back in the days of Palmer and some of the cases preceding Palmer. They would say, IRS, your complaint is that he could have done it a different way, but he chose to do it this way. We're cool with that. Okay. The tax court has been quite open about the idea that a taxpayer is free to structure her affairs in such a way that she gets the best tax advantage. Could have done it this way, could have sold it first and contributed the proceeds, chose instead to do it this way. And I think ultimately, it's all going to come back to enforceability. I would feel pretty terrible about going through a transaction where you actually had not just letters of intent, but actual negotiation over purchase and sale agreements and something that looked like a final agreement, and then have somebody step in and say, why don't we back off this? Why don't we just rescind this and do the whole thing over with the charity in the middle? Okay. I think that is certainly, the charity wants to be protected from any attendant risks there. Private benefit or something of that nature. But I think once you actually have enforceable contracts in place, I would be very skittish myself. But you, Brian, are dealing with this day in and day out, and you probably have a better perspective on it than I do. So, yeah, what's your sense, actually?
Well, I would say it comes up from time to time, and usually what we say is, check with your own advisors, make sure that you're very, very clear as to what those risks are and what the severity of the sort of penalty would be.
Yeah.
And then we, as a charity, are a bit more comfortable in what that then would look like from our perspective. I mean, I would just, to be very open, literally yesterday I sent to Ryan Raffin, our sort of lead compliance attorney, who I think is on the call here today, an IRS summons basically saying we would like to have a series of documents from a specific transaction that occurred in 2017. And now he, even though it was addressed to me, is having to respond to that, obviously, in writing with the information that we have on that side. So these things definitely come up from time to time. It can be much more difficult from the charity side, and sometimes we've actually had situations where, all emails, all phone record correspondence, everything back 2 or 3 years ago on a particular transaction, that also comes up, maybe roughly once a year. So out of 100 transactions or so, but they're definitely looking at it sort of as appropriate. But I want to be a little bit careful on your time. I know you want to go through Fairbairn a bit here too. We have had 2 or 3 really good questions that have popped up. I'm answering some of those, but if we have a little bit of time at the end, we can go through those too.
Well, yeah. So where are we with time? We have about 10 minutes if we're lucky. Fairbairn, actually, as I mentioned, is still pending. So all I need to do is kind of set it up and then identify the issues, and we can try to do that fairly speedily. Am I still on here? Here we go. Okay. So this involved it's not closely held stock. It had gone public several years previously, but the Fairbairns actually did own a position in this stock, somewhat over 10%. They had 12, 13%. They had been angel investors before it went public. The Fairbairns are hedge fund managers, and they had taken this stock on in speculation. And what had happened was late December 2017, the day before they were working on this gift to Fidelity Charitable for weeks and months prior, but they were waiting for the right time to make the contribution. And the timing was that the FCC approved their technology, which has to do with wireless charging, okay, of your cell phone from a distance of 3 feet, 8 feet, 9 feet, whatever, something I'll never buy. But that caused the stock to spike very dramatically the day before they made their contribution. Okay. Um, and so I actually literally have, here's the information on the spike. They made their contribution over a period of 2 days. On the second day, which is where the lion's share of their contribution was made, Fidelity, predictably, according to their policy, sold it all quickly. It happened, hard to say what cause and effect is. It happened that they were in a very strong downdraft that day. And by the end of the day, the stock was way off its opening price for the day. Okay, way off. But on the other hand, Fidelity did pretty well in a downdraft. If you look at the fact that this stock never came back, this spike, I don't have an arrow, I don't think to, does this show as on your screen? Right here is the day of the transaction. That high spike, it fell very dramatically that day, and it never recovered. And where it is today is way under 5. Those days was almost 40. So they got caught in the downdraft, and the question is, whose fault is that? The Fairbairns actually thought, well, we thought we had a charitable contribution deduction of $100 million or whatever that we could carry forward for years. And we thought that we were going to have this DAF from which we could make grants to their favorite charities are medical research institutions that are working on Lyme disease. They've made several very large grants to Harvard Medical School on this subject, probably from this DAF. But it was a lot smaller than they thought it would be. So these are what they were suing for: lost value of their deduction, lost value of the fund itself. And they claimed that Fidelity had teased them into doing the transaction with them rather than JP Morgan by making all these promises about, we're going to handle the stock sale here so much better than JP Morgan ever could. Okay, we won't trade more than X percent of the daily trading volume. And frankly, they said, the Fairbairns allege, that they wouldn't even start selling it until early the following year. And that even then, they would allow the Fairbairns to advise on the price floor. So Fidelity says, well, wait a second. You're basically saying that you wanted to still have control. First of all, we deny that we ever made those promises. Okay. But the promises you're alleging, if they were enforceable, okay, would negate the idea that you're even making a gift. And then secondly, who are you to complain about the value of a DAF? It's not yours. Yes, you have advisory privileges, but it's ours. We own that DAF, not yours. The court actually denied the motion to dismiss on that basis, saying, well, yeah, it's yours, but the Fairbairns have a special interest. We don't have to wait for the Attorney General to take action on this. The Fairbairns individually have a special relationship to this fund. We're going to give them standing to sue. Okay, Fidelity raised that argument again in some motions as trial approached. Okay. And then there was a second motion for partial summary judgment on this question of, if you're alleging that you still had control over how we were going to manage this sale, then you're also saying that the gift wasn't complete, and that's inconsistent with the reporting position you took with IRS. Okay, and the court said, you know what? That's the Fairbairns' problem. Their return is actually still open. In fact, it's still open right now. They filed it in October of 2018. 3 years hasn't even run yet. So the court said, if it turns out that we rule, the court rules that you did make an enforceable promise here and you breached that promise, and if that messes up the Fairbairns tax reporting position, that's on them. Okay, it's not estoppel. Estoppel is if they're trying to whipsaw the IRS. They can't whipsaw the IRS here because their return is still open. So On this unclean hands, this is actually, I think, the last slide on Fairbairn, so I'll just talk about this briefly. One of the affirmative defenses that Fidelity had raised was, the Fairbairns are asking the court here to enter an order based on what's called equity. And you can't ask the court to enter an equitable order if you yourself have what they call unclean hands, if you have been a bad player in this very transaction. And the allegation here was that the Fairbairns were such insiders on Energus, the stock, that they knew that the chief technology officer was about to resign, but he wasn't going to resign until after this FCC ruling came down. So they were close to a point where the stock was probably going to fall, they probably thought. And Fidelity was saying, you just wanted us to be holding the bag. So, we shouldn't be listening to you. So that's where all that is. The court denied that motion as well. They had some trial briefs in September. They had to do this as a virtual bench trial. The Fairbairns originally wanted a jury. I'm not sure how well that would have played because you got hedge fund managers on one side and the big investment house on the other side. And really the flavor of Fidelity's defense was, we use some pretty sophisticated trading mechanisms after all, whether you think so or not. The downdraft was not our fault. As much as it looks like, when we dump 7% of the total outstanding stock in the space of 3 hours and the price falls, that maybe smells like cause and effect, but that's not really what happened. It was a downdraft. We just got caught in it, and actually we did pretty well. So it's under submission. We don't have a final order yet, and that exhausts my screen. So we probably, I hope, did leave time for a couple of questions. Yeah, we did. Let's do it.
Excellent job. Excellent
Okay.
job. Well, I've sort of got a few of these queued up, and obviously anything around Fairbairn, because it's still sort of working its way clearly through the process, but there are a lot. I would say there are more than 1,000 donor-advised fund sponsors now in the country. National Philanthropic Trust, as many of you know, does an incredibly good job of sort of researching and sort of tracking all of that. My only point here is that while this is a Fidelity case, this is very, very common, at least in terms of conversations with large donor positions, whether those are publicly traded or not, for that matter. And so a lot of those fund sponsors sort of watching to see how this sort of plays out and what the maybe not so good ripple effects might be on either side. So we're sort of waiting to see how that occurs. And certainly other questions, post those in the Q&A and I'll do my best.
Yeah.
So one question that comes up, and I get this often too, let's talk about real estate. And so when we're thinking about prearranged sale, what about typically a simultaneous close or transfer and close? So the question really is, purchase and sale agreement contains contingencies, and sale occurs when all the contingencies have been released, so that at closing, the property is transferred to a charity, and then the sale occurs simultaneously. So I guess what are your general thoughts there?
Well, my first reaction to that is, in effect, that's what happened in Palmer. The very case that everybody hangs their hat on and that the tax court still cites in the face of IRS's arguments. The taxpayer was on both sides of that transaction, which is, even one step further than you're talking about. But the idea that this was going to happen was well understood, and they delayed it by 1 day symbolically. It could have been simultaneous, and I think the court would have come down the same way. I think that you raise the odds a little bit by doing it that way, because the question always is, was it a closed gift before the charity undertook any obligation to sell? And if you're literally sitting at the same closing table, I think it becomes harder to make that argument. A lot of tax law looks like this. Throughout this conversation, I've been thinking about 1031 transactions where IRS is looking for two things. They want the qualified intermediary to be independent so that things can happen that the seller can't control. Okay, but obviously all the participants are shooting for the same goal, and the qualified intermediary, in fact, is trying to simply serve as an escrow agent. But when you have related parties in those transactions, the other thing that IRS looks for, and the code actually requires this, is market exposure. did the charity hold this, to take us back to our context rather than 1031, was the charity holding this asset in a way where things could have happened to the value of that asset between when they took it and when they sold it, so that there's actually a difference between selling it first and donating proceeds versus donating the asset and then selling. So the IRS, if you have market exposure, I think they will leave you alone. So that's another reason maybe not to do it at the very same closing table. But again, that's just comfort zone for me. So
Yeah, I would agree. I think it's a great explanation. We never even talked through that before in all the
yeah.
years here, but I would completely agree. And I think there's sort of two things. One, as my grandmother used to say, which I never got until I was like 26, just because you can doesn't mean you should, sort of deal.
Yeah.
And the point is that I think there are some advisors who are very comfortable doing that, to be very, very clear. We actually did a pretty big study in 2017. I think Nature Conservancy does more real estate gifts, which is sort of obvious, than any other charity in the country. We were actually number 2, strangely enough, on a couple levels. We are not comfortable at all with a simultaneous close.
Mm-hmm.
Not so much from a tax perspective, but it's almost like, look, I don't like bulls chasing me, and this to me gets a big, big red cape and sort of flops it all around, and I'm not overly eager to do that, which I think is a more crude way of describing what Russ did much more eloquently. And the point is, it's just getting so close to the sun. It's like, just take the risk, bring it in. Yes, it's a pain. Yes, sort of charities, chain of, all that sort of, I get it all. But, some of this is, how close do you really want to push it? And it's not so much, I think, from the tax side per se, because I think you could sort of win that argument. A, do you want to have it, number one? But B, I think a much bigger issue is follow the bouncing ball. You've got an 8283, then the charity has an 8282. And there's a case maybe 2 years ago that we had one of our donors go under audit. Wasn't real estate. It was an S corp. It was a bank. And I kid you not, they did the assignment of that. I think it was like 10:32 in the morning on a Tuesday. They time-stamped it. Why do you need to time-stamp it? You know why? Because at 2:18 or something in the afternoon, they time-stamped the closing documents. You're like, really? Are you just trying to agitate everybody? So the point was, what does the 8282 say? When was the gift acquired? Tuesday. When was it sold? Tuesday. There isn't a lot of algorithms the IRS have to run through to say that seems odd. So optically, any kind of trigger that's going to be created, that's probably not a good one. So
Right.
I think probably all that could work, but just because you can doesn't mean you should, especially sort of in this space. So with that, I'll close. There are 2 or 3 other great questions that have come in. Again, all the questions that have come in, we will capture, make in a pretty good format, okay? And then Russ will go through, and I'll go through, sort of answer all of those, and then all the ones from Thursday's session as well. So we'll pick the best one. I think it's a pretty good video so far, a pretty good webinar. So then we'll take that recording, take this as a follow-up, send this out next week with a link for everybody too. So thank you so much, Russ, for your incredible tax geek, I say that with love, tax geek insight and background and experience, and you take that with love too.
Always a pleasure. Always a pleasure.
Absolutely. Well, thank you so much. But thank everybody for your time. We all sort of geeked out here a little bit the last hour or so, but these are such important information. This question comes up for us weekly, and so we thought, given what's happened to Dickinson, other kind of cases that are sort of close to that, thought Russ would be, and he was, the perfect person to be able to be our Sherpa through some of these issues. So thank you all so much. Hope it's been helpful, and we'll connect in some future webinar, I am sure. Bye-bye.
Thanks.